not affecting this vacuum.
But Council, doesn't a floating exchange rate divides the currency risk equally?
Madam President, while we do agree that the floating exchange rate on a prima facie basis could seem to have divided the risk between the parties, however, even the application of a floating exchange rate does not de-risk both parties equally. This is because, Madam President, that when a floating exchange rate is applied, the respondent has absolutely no certainty about what would be the final purchase price, as its final purchase price would be determined according to the fluctuations that would take place 5 years down the line when payment was to be made and the price would be calculated. In complete contrast, when a fixed exchange rate was applicable, not only would the parties know the rate at which the costs have to be converted, there would be certainty for my opposing counsel as well, who was going into productions, to keep its costs within a certain level and not be affected by currency fluctuations that could eventually increase their price way beyond the maximum price without absolutely no control over it. And therefore, members of the tribunal, the fixing of an exchange rate based on an estimate of a fixed exchange rate provides that the parties intended a fixed exchange rate. And if I may substantiate my submission in regard to the applicable rate and how the intention of the parties on the records indicate that they were including this structure based on an understanding to apply a fixed exchange rate. Members of the tribunal, in this regard, if you may direct your attention to page 27 of the records. The present contract was not the first contract between the parties. These parties were sister subsidiaries and had already contracted on 2 prior occasions. The email reproduced on page 27 reflects that both parties were physically present at a meeting. It's the email by Jan Mansbury. Yes. This email reflects that not only the respondent, but even my opposing counsel's client's CEO, Ms. Sakadura, was present at a meeting where it was discussed and agreed between all the subsidiaries of their common parent that in contracts with respondent, there would be a fixed exchange rate applicable. Now, as my opposing counsel itself has stated, that the exchange rate has massive implications, and therefore, parties commercially entering into a contract worth $20 million would normally negotiate this rate. However, in the instant case, the reason why the parties did not engage in negotiations for the exchange rate was because they already had an implicit understanding about the applicable rate, and there was no need to derogate from this rate as evident from the records, since no negotiations to alter this understanding were undertaken. Members of the tribunal, if I may therefore address the issue regarding the addendum that has been pointed out by my opposing counsel. Now, my opposing counsel indicates that the addendum was seeking to modify the contract. However, it is our submission that the addendum as an instrument was simply used to supplement the understanding that had already existed between the parties.
Mrs. Cholera, how do you reconcile the contra preferentum rule mentioned by the other counsel contained in Article 8 of CISG with your claims?
Madam President, members of the tribunal, Article 8 of the CISG governs the contractual terms, and it specifically provides under Clause 2 that whenever terms are negotiated between the parties, both parties have equal bargaining power. There is no applicability of the contra preferentum rule. And this is because the use of a contra preferentum rule is usually adopted either in standard terms included unilaterally by one party or in an attempt by the tribunal to simplify the imbalance created by parties engaging in transactions emanating from unequal bargaining positions. And therefore, in the instant case, as both parties not only negotiated and had enough time to understand the implications of this addendum, both parties were at an equal standing when they negotiated this addendum, and therefore the contra preferentum rule should not be applicable against my client. Madam President, Our opposing counsel has also relied on page 28 of the records. If you could direct your attention to that page available on page 28, it reflects an email. Now, my opposing counsel has directed your attention to the subject header of this email, which states clamps. However, just because the parties had a subject header clamps, we request the tribunal to not restrict the contents of this email. As even previously on page 12 of the records, it is indicated that the parties had used a subject header payment of TRF 192.1, which is the fan blade, and the contents of the email included payment details of the clamps as well. Page 12 of the record. The subject header stated payment TRF 192.1. It also included payment details of the clamps. And therefore, before we proceed to the interpretation of this email, we request the tribunal to not restrict the contents of this email based on that subject header. Further, members of the tribunal, the parties in the introductory line of this email have stated that they did not want a separate contract for the clamps. And this was not done because the parties lacked resources to draft a separate legal instrument, but was because they wanted to conveniently link these two agreements, as both these products were intrinsic to each other. The clamps were required to attach the blades to the shaft of the jet engines, and therefore an instrument like an addendum was used specifically to be inserted into the contract for fan blades, and therefore the clauses in the addendum cannot be viewed restrictively in the context of clamps and have to be looked upon in the context of the contract that it was now being a part of. In this regard, members of the tribunal, the interpretation that my opposing counsel suggests that the parties would explicitly regulate an exchange rate for a contract of clamps worth $100,000, but not do the same for a contract worth $20 million, on which the implications now the opposing counsel is itself suffering. Members of the tribunal, it was this very implication that my client wanted to avoid and had insisted upon an explicit clause. And this was also in accordance with the normal practice of the aircraft industry, as reflected on paragraph 13 of the procedural order 2. And therefore, in this regard, I have really exceeded my time, and I would request only 30 seconds to conclude my submission. Members of the tribunal, our client does not have any outstanding payment obligations based either on an application of a current exchange rate or on the investigation levy, as it was not informed about the same by the opposing party. Thank you. If I may be of no further assistance.
You might be of further assistance, thank you. I am very drawn to your appeal to common sense to follow the money, in that if the proceeds of a levy go to the government, it's a government fee, not a bank fee. How do you clear out of the path of that argument the UNIDROIT rules, particularly Article 6.1, which appears to put on you, your client, the full cost of its performance? And if its performance is to pay a certain amount of money, it would appear, whether this levy goes to the government or to the bank, that it is a cost of your performance.
Mr. President, now we do recognize that 6.1.11 of the UNIDROIT principle requires every party to bear costs of their performance. However, we can only look to the UNIDROIT in absence of a provision in the CISG. And since the CISG does govern the payment obligations of a buyer under Article 54, we cannot turn to the UNIDROIT principles to further include obligations for my client. And in regard to Article 54, it is our submission that while compliance with regulations was within a buyer's obligation, but such regulations which the claimant has not informed us about cannot be imposed on as well. And therefore, it is our submission that in absence of any information from the opposing party regarding this regulation, our client should not be burdened with the obligation to pay $100,000 extra under this contract. Thank you.
Thank you. Mr. Ahija, would you respond to this issue directly?
I have two brief points of rebuttal. First,
Before we get to rebuttal, would you address exactly what we've just heard from counsel?
counsel has stated that Article 54 does sufficiently address this. Now, on this point of not resorting to the unidraw principles, we should note that the word any before laws and regulations in Article 54 was added into the CISG by the drafters, and it was not present in the predecessor to the CISG, which was the ULIS. These drafters recognized that the buyer has fewer obligations and therefore has no excuse of information or non-information except for impossibility, and therefore even if we do not resort to 6.1.11, we would still find that Article 54 sufficiently addresses this and places this obligation upon the buyer.
Okay, thank you. Any further questions for Ms. Chilera? Okay. Mr. Rahija, rebuttal, please.
I have one brief point of rebuttal. Now, opposing counsel has stated that the purpose behind the contra preferentum principle would be defeated if we adopt it here. However, as Professor Honnold has stated, the purpose of this principle is to avoid malleable and opportunistic drafting, and hereby adding the word agreement in this clause, on another day, if the rate had gone up, respondent could be restricting this term agreement and this clause to the clamps, while today the same word is allowing them to argue that it pertains to the fan blades as well. Therefore, the purpose of contra preferentum is most appropriately applied here.
Thank you. Ms. Chilera?
I have addressed the contra preferentum rule in my submission and have no further, sir, rebuttal. Thank you.
Thank you. Are there further questions from the tribunal on any of the points raised? Counsel, thank you very much for an enlightening and enjoyable proceeding. The hearing is now closed.
Well, thank you to our wonderful representatives of the claimant and the respondent, and to our wonderful panel of arbitrators. What will happen now is that the arbitrators will retire and will consider their deliberations and their decision, which will, of course, be announced towards the end of the gala lunch, which is going to follow. But between then and now and then, I'm going to ask you all to leave the room and take with you anything that you have brought, everything that you've brought, and the photograph. We have a mass photograph, which is usually fun, and most people want to be in it. If you want to come down to the photograph, you'll be led to a place where everyone will gather. And we hope that the tribunal and both teams will also join us. The teams can come down now, the tribunal when you're ready, so that we can all get together for a photograph for posterity. Now, there is a place downstairs near the entry where you can leave your large bags. If you've got knapsacks or computer bags, anything bigger than a small handbag, we ask that you please check that now before you go to the photograph, and then we'll meet over there at the photograph. The photograph will be taken about 12:05, and after that we'll come back here and you'll be asked for your tickets. So check your pockets now and see whether you have your gala ticket in the pocket, because if you don't, you'd better go back to your hotel or wherever you have it and find it, because nobody comes in without a ticket. All right, that's the rule. Your ticket, of course, has a table marked on it, and so you'll sit at the table which your team has been allotted, or if you're an individual, you'll be at a table that you've got a number. The two finalist teams will be sitting at these two red tables here. There are 3 head tables, and we don't mind where you sit at your head table. There will be specific places for the head table. That's it. So it's now 11:15. You've probably got time not only to check your bags, but maybe to have coffee. And then I won't tell you the address because you won't find it. You'll be led over. There'll be people on the way to show you how to get there. All right? So let's do that now. Pick up everything. Don't leave anything on the tables. Don't leave anything under the chairs.